Okay, we're on our sixth video and we're looking still at the respondent brief, and now we're looking at the undue burden part of this. Again, the key thing here is, as we already talked about in the previous brief, Abercrombie is arguing that their expert testimony or their executive testimony clearly shows that Abercrombie met the de minimis cost burden that would be caused by allowing Eloff to have an accommodation to the look policy. Clearly, what we're looking at here when we get to the respondent's version of that is that the EEOC is arguing that their information is not data-driven, that it's too much based on speculation. And so you can see several references that go through this. So you can see in this paragraph that, looking in the middle here, any hardship asserted, furthermore, must be real rather than speculative. EEOC is arguing that what Abercrombie say is speculation, or that it is a conceivable or hypothetical. None of those would have been allowed. The second thing that they talk about is that Abercrombie has provided employees with reasonable accommodations similar to the ones sought by Eloff, and so they could have done some studies, but they didn't. That doesn't mean that they're wrong, but this is again part of what the EEOC on behalf of Eloff is arguing, that they needed to have more specific information. They should have done some studies. And then you can see that, again, here they're accusing them of not being able to be non-speculative or non-hypothetical. The point is that they were being speculative and hypothetical. And that's the key to this argument. You want to look for cases that basically support the idea that Abercrombie needed to be more precise, have more specific data, done some studies that indicated this would cause harm. When you're dealing with Abercrombie's version of this on the appellant side, you're arguing that they met that minimum standard when their experts explained why they thought this would do harm both to Abercrombie, both to the look policy, and to the brand, and both to their ability to enforce the look policy. And let's see. That's really about it here. Again, the point is that their expert testimony was not specific enough. Look at the points where the cases support this idea that they have to be specific, and they weren't. They had given people accommodations. They didn't do any studies to see if that was harmful. And you can see that that's pretty much what they go through until the end here, and then ultimately, clearly, the court ruled in favor of EEOC. So that's a really short one, so I'm going to use this to kind of just summarize the respondent brief. Again, the key thing is they're making an argument that you need a more flexible approach to what is notice, and so just because Eloff didn't give that notice, it still happened because Gannett knew she was Muslim and that she was wearing a head cover because she was a Muslim. And then the second point they're making is that the undue burden proof is not specific enough. It is speculative. It is assuming that there's going to be a problem. And especially because they gave some exceptions to people, the fact that they didn't do studies on that, they believe hurt their ability to prove undue burden. So that's going to be it for that. And then I'm going to go ahead and review the precedent cases that you're given in the second link that are provided on the website.